Hearing the appeal, keen on the application bank and another, against Secretary of State for the Home Department.
Yeah.
Hello, my lady, good morning. You have the class sheet on the Supreme Court's publicity sheet, so I'm not proposing to go through that unless you'd like me to. I'm just going to pitch straight in, if I may.
Yes, please.
This is a case about the statutory scheme, which is accurately and fully set out in the Court of Appeal's judgment, if you have that to hand, at paragraphs 4 through to 14. Electronic page number 478. If you want it in the raw.
I'm afraid so.
Very good. But it's the salient parts are at 4 to 14 of the Court of Appeal's judgment. The purpose of the scheme is to make provision in the immigration rules, which represent, as you know, the Secretary of State's policy governing different aspects of immigration, make provision for high net worth individuals who are able to and wish to make a substantial financial investment to the UK. And I take that wording from Rule 245E, which is set out in the Court of Appeal's judgment at paragraph 5, and it provides this route, that is a route for them to obtain a particular species of leave to remain. This route is for high net worth individuals making a substantial financial investment to the UK. And the rules then set out, as the Court of Appeal summarises in the following paragraphs, a series of provisions that are designed to secure that aim or purpose.
Can you just guess we're on the same page numbers?
I think we're 125 for Court
We've
of
got to
Appeal.
use a bundle, please use
Yes,
this one.
we received a whole succession of competing bundles. The final version headed use this one.
Yeah.
And 478 of that one is not what is not.
Oh yes, I've got 478.
Well, I've got 125.
The 125 is the Court of Appeal judgment.
Right, okay, sorry.
My Lord, I'm sorry, maybe confusion. So the Court of Appeal judgment is at 125. I had a gossip for gossip, and I thought,
That's the first page of it.
That's the first page.
We're on the same system.
Yeah. So paragraph 5 is at 126, and the reference I gave you when my Lord Briggs asked for the rules in the raw, I hope should be at 478.
Yes, that's right.
Good.
Okay.
So we can all be the collective side.
I'm responsible for the chaos.
No, well. I hope we're on the same notes. But I'm going to take it from the Court of Appeal's judgment, if I may, because that may be a more convenient collation. That starts at 126. The passage I quoted, setting out the purpose of the rules, is at the bottom of 126 electronically. Do you see the reference in the penultimate line of 126 to Rule 245E? And that's the bit I read out to you.
Yeah.
And if one just traces it on, the requirements that I was referring to are then summarised at paragraphs 6 and following. So in a nutshell, the scheme is contained in the box at paragraph 8 of the Court of Appeal's judgment on page 127. And what you have to do if you're an applicant is to earn, if that's the right way of describing it, 75 points, which means that for this particular route you've got to satisfy all 3 boxes, because 30 plus 30 plus 15 equals 75. So you've got to satisfy all 3 of the boxes in table 8b, quoted at paragraph 8 of the Court of Appeal's judgment. And the debate here is essentially turned on the alternative in box 1, that is B, and particularly B sub 2, i.e. B Roman 2 in box 8, has money under its control, read with the exclusion in paragraph 65 of Appendix A.
The B1, the personal assets of a value of not less than £2 million, those can be assets anywhere in the world, can they?
My lady, I think they can. I've written anywhere in brackets next door to that, if my reading of it is correct.
Yes.
That seems to be the distinction. So you've got those two alternative routes of demonstrating that you have the requisite cash initially, as it were, and then the investment bit is dealt with in the second box. And again, the Court of Appeal have helpfully highlighted the key features of that. So if you've got the £1 million, as it were, by way of borrowing, you've got to invest at least £750,000 in active and trading UK registered companies, subject to the restrictions set out in paragraph 65 below. And paragraph 65, if you flick over the page to 128 if you're electronic, to paragraph 13 of the Court of Appeal judgment, that sets out an exclusion of companies that you can't invest in effect, and that's where you get the reference to the 4 types, the open-ended investment and all of that. Just one other rule to note, which is the note which is noted in the judgment of the Court of Appeal at paragraph 6, and that is Rule 245 ED brackets E. And you see that referred to in their summary of the requirements. That it's the 3rd point in paragraph 6 of the Court of Appeal's judgment. As you see there, the assets and investment the applicant is claiming points for must be wholly under his control. That's where you get the reference to wholly from. So that's the essential statutory scheme. As I say, no quibble I think anyone has with the helpful summary and identification of the relevant parts in the Court of Appeal's judgment. And just turning briefly to the questions that gives rise to in this context, a broad legal framework, as it were, the question ultimately, for the upper tribunal at least initially, was whether the conclusion of the Secretary of State that this applicant did not satisfy those conditions was one which was rationally open to her. So this is a public law challenge. Of course, as such, that breaks down into 2 bits on traditional public law principles, because the interpretation, the true meaning and effect of immigration rules as an expression of policy by the Secretary of State, but the interpretation of those is a matter for the court. That's Raisi and all cases that flow from Raisi, which I'm sure my lords and my lady will be familiar with. But the judgment about whether or not you fall, or a particular set of facts fall within those rules, properly interpreted, is a matter for the rational judgment of the Secretary of State. And of course, superimposed on that framework, that's the right way of viewing it, is the appellate framework. The question for the Court of Appeal was whether or not the upper tribunal erred in law in its interpretation of the rules and its application of that public law test to the extent that issues of judgment were involved. And the question for this court is essentially the same, whether the Court of Appeal were right or wrong to conclude that the upper tribunal had erred in law. I wanted to touch very briefly, although I don't think it's controversial, I wanted to touch very briefly on the principles relating to the interpretation of immigration rules, because those principles of interpretation of that scheme of rules is an important part of the legal framework. The key passage, or passages, if I can take it from our case, if I may, I'll give you the references if you want the authorities' references in a second, but the key references on that subject are set out in our case at paragraphs 12 to 16. So our case is at page 50 electronically. That should, I hope, take you at the bottom of page 50 to paragraph 12. And you will see there the very well-known passage from Lord Brown in a case called Mahad. If you wanted to write next door to that notion into the actual case itself, it's the case itself, and that paragraph is at page 759. You want the case in the raw, but as I say, I don't think it's terribly controversial. I wasn't proposing to turn it up specifically, but you'll see what is there said by Lord Brown. The rules are not to be construed with all the strictness applicable to the construction of a statute or a statutory instrument, but instead sensibly, according to the natural and ordinary meaning of the words used, recognising that they are statements of the Secretary of State's administrative policy. And indeed, the Court of Appeal correctly acknowledged that that was the right approach. And we've taken from that and from that passage in Lord Brown's judgment in Mahad the basic message that the overall policy intent of the rules in the context of immigration policy is of particular importance. If you will, rigour of construction, no doubt, but not overly technical, please, appears to be the core and basic message from that passage. And you get the same idea reinforced in the judgment of Lord Justice Holroyd that you see cited in the next paragraph of our case on page 51, in the Sajjad case. And again, if you want the references to the paragraphs that we've there cited in the raw, they are in the electronic bundle at page 1003, but you'll see what is said there by Lord Justice Holroyd about the approach to interpreting the rules.
That was common ground below.
That was common ground below. It was, my lord, as I think the Court of Appeal recorded and as we acknowledge.
Thank you.
We also submit that the appropriate approach when looking at a scheme of the kind that we have in this case, the appropriate approach, particularly given the approach just described in Sajjad and in Mahad, is that it is plainly appropriate not merely to focus on the individual steps in a series of linked steps, if there's a scheme with linked steps in it, planned in advance. It's clearly appropriate to consider the scheme as a whole, or in the round, in order to determine the true significance and the true matters to be drawn from the individual elements of those linked steps. And we take that as the correct approach from the Rossendale case, which at least some members of the court will be familiar with. The judgment, the principal judgment in the case, I think, was given by Lord Briggs and Lord Leggett for the court. And the Rossendale case, again, you see cited at paragraph 16 of our case. It may just be worth briefly turning that up, if I may. It's at page 1021 in the authority. 1021, I'm hoping, will take you to paragraph 12.
Yeah.
And can I just invite you to cast an eye down at paragraph 12 first, and then briefly paragraph 17, rather than reading them out.
And 13.
12 and 17, if I would. I mean, the whole passage between 12 and 17 is worth a read, but the two particular bits were paragraphs 12 and then 17.
Submit or accept that the McNiven principle quoted at the end of paragraph 14 is equally applicable to the immigration rules as it is to statutory construction?
Yes, I do.
Yeah.
I do, of course. But I do submit that paragraphs 12 and 17 and the principle they espouse or they set out, are deliberately expressed by the court as being points of general principle, as you see in paragraph 12, so that if you're dealing with a scheme, marketed type scheme, and most tax avoidance schemes are marketed, and this type of scheme is marketed also, if you're dealing with those sorts of schemes where you've got a series of pre-planned linked steps, the appropriate course is to stand back and look at the wood for the trees or not to look at the trees for the wood, if it's the right way around, but to look at the picture as a whole, to consider the scheme as a whole as it's put in paragraph 12, or in the round as it's put in paragraph 17, in order to determine the true significance of each of the individual elements of it. You don't just focus narrowly on an individual element without taking into account the entirety of what the scheme is designed to deliver. And that is, lest it be said this is a principle that just applies to tax avoidance schemes. True it is that it does apply to tax avoidance schemes, particularly marketed ones, but it's deliberately expressed, as you see from paragraph 12, as no more than an application of general principle. And we respectfully submit that must be right, and it must apply a fortiori in a scheme such as the immigration rules, because the immigration rules put a particular premium on adopting a realistic and not overly technical interpretation. That's how we put it. So that's the significance we derive from the helpful analysis of the court.
So our case is analogous to a tax scheme?
My submission is yes, for this purpose and for the application of these principles, and particularly so because of the approach generally that you take to immigration rules per Lord Brown.
Well, if one looks at the traditional approach then and applies that, in this case the first step is to interpret the words that are there in the context of the purpose as expressed in the
Yes.
legislation, and the question we're looking at is the question of what is the meaning of control.
We are.
Now, do you say that before you get to Rosendale that the interpretation in accordance with what's in paragraph 12 of your submission gets you the meaning of control, or do you say that you then have to take the second step, which is to apply the Rosendale approach before you get that meaning?
Well, I could do either or both, is the
Right.
short answer
Well,
to that.
okay.
But my submission is that control has got, I'll come to the meaning of control obviously because that's the stuff of this first round, but
And when you say that the second step is the Rosendale approach, that must also be for the purpose of deciding what control means, is it?
yes. What I do is to rely upon the principle that Lord Brown set out as to how you approach immigration rules, realistic and not overly technical, and as part of that exercise, one slots in, as an approach of general principle, the Rosendale approach. Now, true it is that Rosendale was itself a tax avoidance scheme, but it was deliberately cast as a point of general principle, and correctly so, because if you're dealing with a series of pre-planned steps, you must view the thing in the round.
But it must, in this case, come back to telling you what control means.
It must. It must inform that. How you go about doing that, how you look at that. When you're looking at the question of control, that first step is at least not to be viewed in isolation, but is to be viewed as part of a composite whole, which in our case, as in an ordinary tax avoidance scheme, will often comprise, and here does comprise, a series of linked steps agreed in advance.
I mean, just looking at the compression of all that into the dictum in Arrowtown at the end of paragraph 30, of course, you take a purposive approach to the construction of the relevant provisions of the rules, and a realistic approach in the application of the rules thus construed to this particular scheme.
Yes.
Yeah.
Yes. And I gave you the purpose initially, particularly expressed in 2545E, but my Lord, yes, my principal concern here, accepting all of that, my principal concern here is to ensure, as it were, that one doesn't fall into what I submit will be the wrong approach of principle, which is to narrowly focus on particular elements of a series of planned linked steps without standing back and looking at the thing in the round.
Well, the old approach of looking at scintillas of time that technically elapse between one step and the next, that's kind of knocked out by...
That I submit is knocked out. But you're also entitled particularly to adopt this approach of standing back and looking at the thing in the round and as a whole for the purpose of judging what each particular step involves. You are entitled to adopt that approach, I respectfully submit, particularly in a context in which, we'll come to the detail in a second, but in a context in which, as is often the case in marketed tax avoidance schemes, the particular elements or components that are linked of the scheme bear on their face a legal or commercial description which, when you look at the scheme as a whole, bears little reflection to reality. So you call something a loan, freely negotiated, one would expect to find the ingredients of a loan, and you don't get something that looks very much like a loan. You look for the next stage, which is investment, you get something which doesn't look remotely like an investment, and you stand back and look at the scheme as a whole, not to jump too far ahead, and you see swirling money going round in a circle, for which, when you take all of the agreements together, you ultimately get something which looks like a £200,000 fee for a series of linked steps where the money never leaves anyone else, and you just end up with a big fee being paid for an appearance. That's going to be the essential submission.
As identified by Lord Justice Nugent at one point in the discussion.
Yes, and my Lord, correct, but also identified by the Court of Appeal themselves, particularly in the expressions of regret, in paragraph 69 in the judgment of Lord Justice Underhill. Our respectful ultimate submission is going to be that the Court of Appeal were right to be troubled in their gut, if I'm allowed to put it that way, and they correctly identified the truth of this set of transactions, this set of linked transactions. They identified the truth of it, and they identified correctly what the facts were, and then, as it were, didn't attach the correct legal significance to those. That's why I start with this as the correct approach in principle. Well, that's all I wanted to say about the correct.
At some stage going to have a close look at the wording of the table.
We are, I hope. I was going to start with the key features.
I'll defer any questions I've got until we get to that.
But it probably might make sense to do that unless you want to delve straight in. I was going to go next to the key features of the arrangements themselves. So, as it were, a little introduction to the facts before we come to the detail of the table, which I'm sure my Lord will have identified isn't necessarily logically perfect in all parts. So, to turn them from the correct approach in principle to the key features of the arrangements, the factual detail, again, is correctly summarised and helpfully summarised by the Court of Appeal in setting out the ingredients of the scheme at paragraphs 15 to 29 of their judgment. I'm going to come back to the specific detail in a moment and go to a couple of the agreements just to show you a flavour of it, but we have no quibble with 15 to 29 of the Court of Appeal's judgment. I wanted to make two key points at this stage before coming in a little more detail to a couple of the agreements. The first point is that the arrangements, and it was a take it or leave it set of arrangements, were precisely set up so that Ms. Wang was never in control of the funds originally loaned by MAM to her. The £1 million, the subject of the MAM loan, was controlled at all times by, if I can use the initials rather than their name, by DK and NK, the actual individuals, the Russian individuals who sat behind this series of companies. It was controlled at all times by DK and NK. As the Court of Appeal themselves put it, in paragraph 69, the money was, as they put it, originally controlled by Maxwell and then received back through Eclectic, nominally through the migrants, but, underlined, without losing control at any stage. And see the judgment of the Court of Appeal at paragraph 40 as well to the same effect, referring to the fact that MK and NK retained control of it, that's the money, at all times. So at stage one, there was no option but to have the funds provided by MAM to Eclectic. There was no ability to decide how the loan money should be used. It was not available for use by Ms. Wang, subject to repayment terms and the other normal incidents that one would expect of a loan. Instead, it had to be transferred in a single advance, that's the wording of clause 3.1 of the MAM loan agreement, to Eclectic. And at stage two, that control was maintained when the money arrived at Eclectic, a company owned and controlled by NK, no money would have been advanced by MAM unless the back-to-back loan agreements between Eclectic and Ms. Wang had been signed on the terms set out by Eclectic. And those terms, I'll come back to this, were set up so as in effect to generate or to support the fee arrangement that I've described, rather than any form of what one would normally describe as being an investment relationship, where normally a party can expect to have some stake in the investments that are made. There was no ability to control the money at this point in the hands of the individual. Ms. Wang had no entitlement to call for the money from Eclectic, and none of this was accidental. It was the essence of the series of linked steps in the arrangements. And that was because unless control rested with DK and NK and their companies, their vehicle companies, the agreements or the arrangements would have been commercially completely incoherent. They would have involved unsecured loans to private individuals of untrusted creditworthiness who might simply disappear. See, for that description, Judgment of the Court of Appeal, paragraph 40. And for that reason...
Well, we know that they've got £2 million worth of other assets, though.
My lady, yes, at a particular point in time, but none of that was pledged as security, none of that was provided as security under the arrangements. And as the Court of Appeal rightly found, you have got, as I say, otherwise, unless the control is maintained within that cycle by DK and NK, you've got a series of unsecured loans. People who may or may not have that money tomorrow. That's the first point I wanted to draw out from the as an overarching point. The second point is that it was also of the essence, this scheme under which the money never left the control of DK and NK. It was also of the essence because this was a scheme that was not on any sensible view about high net worth individuals deciding to make a substantial investment in active and trading UK registered companies at all. That also is recognised in the Court of Appeal's judgment at paragraph 69 and in Lord Justice Undale's expression of reluctance in his short judgment as well. The scheme in its component parts, and particularly when assessed in the round, was a marketed scheme. That's the description in paragraph 15 of the Court of Appeal's judgment. It was a marketed scheme simply designed to be able to be presented as satisfying the immigration rules without any true investment by the high net worth individual of £750,000 or £1 million or anything in UK trading companies. It was rather a set of back-to-back, in inverted commas, loan agreements under which the money never for a moment left the hands or the control of the companies of DK and NK, and under which the terms, from the individual's point of view, were simply that they would pay money by way of a fee for the privilege of that presentation. £200,000, as it turned out, paid to a company called Maxwell Holdings under a services agreement between Ms. Wang and Maxwell Holdings, signed by DK on behalf of Maxwell Holdings, in return notionally for agreeing to arrange the loan from MAM, arrange the investment of the loan money, cover all the interest, and guarantee repayment of the principal. So it was simply a fee of £200,000 paid for the presentation, along with the strangenesses of the ability to convert into preference shares and the discrepancy that created between the payments under the MAM loan and the payments that were due back to Ms. Wang under the Eclectic agreement. But that was the truth of it. That was the stand-back position. That was the reality of it. That was what it was designed to create. And it bears, therefore, all the hallmarks of something at least akin to the sort of arrangements and setup one would expect to find in some of the worst tax avoidance schemes. As far as the detail is concerned, can I just invite you to go to the services agreement, if I may, first of all. The services agreement you will find at page 1494 in the electronic bundle. And this was, I'm sure you will have picked it up from the upper tribunal judgment, the upper tribunal being, if I can put it politely, less than impressed by the fact that this services agreement was only produced for the first time during the oral hearing before them. It wasn't produced to the Home Office as part of the application, and it doesn't appear to have been produced at any point up until the oral hearing, where following questions, it appears from the upper tribunal, it was then belatedly produced. But if you go to the services agreement at 1494, I should add that it was referred to in some detail by the Court of Appeal in their description of the scheme, 15, 23, 25 to 27 in the Court of Appeal's judgment, when considering the reality of the scheme. And in large part, this based their conclusion at paragraph 69. But you will see, if you notionally turn the page from the covering page, this is an agreement between Maxwell Holding Limited and Miss Wang, and you will see, if you go forward briefly to the signing page on page 1500, that it's signed on behalf of Maxwell Holding by DK, and he, I think, is the sole director and shareholder. Under this agreement, just to pick out the salient parts of it, Ms. Wang was to pay Maxwell Holding a fee of £200,000 up front. See, for that purpose, clauses 1, just defining services fee. Do you see the last of the definitions on page 1495? £200,000. And then 3.2, the client shall pay the services fee under this agreement on page 1496. And 3.8 on 1497, according to this agreement, the client shall transfer the services fee to the company's bank account within 30 days from the date of signing of this agreement. You will also see that under this agreement, the various services that are agreed to be provided by Maxwell Holding Limited are there set out. Go back to 1495, clause 2.1. The company shall provide the client. The company is Maxwell Holdings. Just bear in mind, the company is Maxwell Holdings. The manager is Maxwell Asset Management, in other words, MAM. See the definition of the manager in clause 1. But back to 2.1, the company, as Maxwell Holdings, shall provide the client, that's Ms. Wang, with the services pertaining to the client's intention to obtain a UK visa Tier 1 brackets investor, so the purpose is tolerably clear. And you'll see the various services that are provided in 2.2, and they include, perhaps relevantly for the purpose of assessing the commerciality and true nature of all of this, just have a look at 2.3, if you would. The company, that's Maxwell Holdings, i.e. DK, will conduct negotiations about the loan arrangements on behalf of the client and on terms agreed with the client with the manager. The manager is MAM, so don't imagine anyone was envisaging that that was going to be a particularly rigorous negotiation, given that it involved DK negotiating with himself, because DK is also MAM, shareholder and director. But you also see in the second bullet under 2.3 that the company that is Maxwell Holdings, will act as guarantor, no provision for security of any kind for that guarantee, of the client's loan repayments to the manager, to MAM. And will also, that's Maxwell Holdings, ensure the timely execution of the client's loan interest payment schedule by the client without the involvement of extra cash. So effectively covering the interest liability and covering the principal. Under 3.7 and the schedule of activity as it's described, if you go forward to page 1497, you'll see that a power of a complete, as it were, a power of attorney is to be granted by Ms. Wang to Maxwell Holdings. And under 3.7.1, Maxwell Holdings agrees to ensure, we put this alongside the negotiation provision we've just seen in 2.3, it's obliged to ensure the provision of loan facility to Ms. Wang by MAM in the amount of £1 million. Term is 5 years, and you'll see the remaining provisions of that. And then if you keep casting your eye down, 3.7.2, so that this is Maxwell Holdings agreeing that it would be under an obligation to ensure that MAM invest the client's borrowed funds in the authorised instruments within the requisite period of time. And that's to be read with 3.7.4, also agrees to ensure the monitoring of the client's investment in such a way that during 5 years the value of the client's investment in authorised does not become less than £1 million. The choice of specific instruments is at the discretion of the manager, that is MAM. So the position is that there is no choice about where the money goes. It's envisaged in this agreement, there's no choice about where the money goes. Everything is going to be negotiated with himself by DK between two companies he owns and directs. And not merely is there no control over where the money goes as far as MAM is concerned, because that's going to be done by Maxwell Holdings, but there's no choice about, ultimately, which instruments it's invested in is at the discretion of the manager. That's the discretion of MAM. So effectively, what appears to be, no wonder the upper tribunal, it might be thought, was interested in what this agreement showed about the true nature of whatever else one might be able to derive from the underlying documents, because what this does, effectively, what this envisages, is that the person organising the scheme, DK, would negotiate with himself. The money would go spinning around companies owned and controlled by him or his wife. That this organising company would at least notionally pay the interest on her behalf and act as guarantor in respect of the principal, all of which entirely unsecured. In effect, no financial risk in respect of the 1 million, because there's going to be no further call for any monies. They're going to ensure that there's no need for more money to be put into the scheme. So this is 1 million spinning round, for which services £200,000 is paid, with no control, as the Court of Appeal correctly noted, at any point in the cycle. And for good measure, with the, in inverted commas, investor being insulated, in effect, from any actual investment risk, and no ability to decide where the money is to be invested. So that is the late disclosed document which, as it were, provides the best indication of what was envisaged by all the underlying documentation that had previously been disclosed. you have the...
3.9 appears to be right for the services fee going back to the client if she doesn't get her visa.
Yes,
Yeah.
that's the only circumstance in which it might be refundable.
But it is in that sense a success fee.
In that sense, a success fee it is. But it's a success fee for as it were, for the presentation. The question is whether it actually does, these various elements truly do what they say on the tin. Oh yes, 3.9 I think is the only one envisaged. Then if you wanted it, you then have the loan agreement between Ms. Wang and... Sorry, just before I go there, I should identify an additional agreement to that services agreement, because there was a bit of addition to 3.7.3 which we looked at. We looked at that, ensuring the interest on the loan in such a way that the client does not insure any additional costs to pay for such expenses. If you go back in the documents to page 459, you will see an additional agreement to the services agreement, and you'll see that there was an amendment to 3.73. May not add much to the overall scheme of things, but you'll see what it says on page 460.
Does it mean incur rather than insured?
I think it does. It certainly does not mean insure with an I. It does not incur. I think it must be incur. That's the sense of it, I think. So that's the services agreement with its addendum. Then the loan agreement between MAM and Ms. Wang, page 468. And under that agreement, look at page 469, if you would, clause 2.1. That's the lender will lend, lender being MAM, £1 million. Look at the purpose of the facility, or the revealing, to enable the borrower to meet the requirements, 2.2. The reference to drawdown as a single advance, which I referred to earlier as 3.1. The date of repayment is determined by the lender, that's MAM, in its sole discretion, considering the symmetric repayment from, effectively, eclectic to the borrower. And then interest is 3% per annum, notionally at least at 5.1 on page 470. And then the term of the loan is 5 years, as you see from 6.2.2. And just note under clause 8 that Ms. Wang is prohibited from assigning or novating the agreement or any of the rights and obligations under it without the prior consent of MAM, clause 8. So that's, as it were, the MAM to Wang side of the symmetric agreements. Then if you go to the eclectic agreement, which is the money coming back to Ms. Wang, that's at page 464. And you'll see that the amount, the capital amount and the term is effectively the same, symmetric. See clause 2 on page 465. Then under repayment, the title of clause 4 is at page 465 at the bottom, and the substance of the clause is at the top of page 466. The date of repayment is determined by the borrower in its sole discretion. though Eclectic can decide all of that. And you see under interest, the interest rate on the loan is 3.05% per annum, which would at least suggest on the face of it, a small profit for Miss Wang. But if you go back to 4.4, that gave Eclectic the uninhibited unilateral right to decide to convert the loan into preference shares in Eclectic, so that the nominal value of those shares was £1 million.
2.2%, I think.
Yes.
Where do we get 2%? Not in 4.4, is it?
It's not in 4.4. Can we just track down that reference?
Yes. It's a fact that they were 2%.
It's a fact that they were 2%.
The share agreement, maybe it's in the share.
I think it might be. We'll find that in the rule, but I think the Court of Appeal judgment correctly noted it. We'll find you the exact reference. It was paragraph 18 of the Court of Appeal's judgment. As they noted, the loan was in fact converted into preference shares, which carried an annual dividend of 2%, i.e. less than the rate of interest payable by her on the loan, and the payment of the dividend was deferred for at least 6 years. And indeed, Miss Wang was prohibited from redeeming the preference shares for 6 years, in other words, until after the man loan would have fallen due for repayment, even though the date of repayment under the Eclectic loan was entirely at the discretion of Eclectic.
But I think my question is the 2% to be found in the bundle of agreements originally signed, or just something done by Eclectic?
We think it was in the Articles of Association, which is not in the bundle, but the Court of Appeal judgment of paragraph 19 we also think is accurate. They must have had.
So just remember the page 1 or something?
It is page 129, paragraph 19 of the Court of Appeal's judgment.
It's 18, I think.
Paragraph 18, I'm so sorry. Oh, well, I'm sorry, thank you. My little buttons. Great.
So that it would be 2% would be gathered by someone signing by Ms. Wang, as it were, in advance of signing it, even though it's not specified in clause
4.4, I think that's right.
Yeah.
So you have the nature of the agreements. There you have it. They're a pretty strange hodgepodge of things for someone to sign up to, unless the intention was, as it self-evidently was, and as is revealed by the services agreement, for the money to do that, for no money to have to be put in, for the appearance to be created that £1 million was being dealt with in a manner that was provided for under the relevant boxes of the immigration rules, and the true arrangement was ultimately for the money to stay under the control of DK and NK throughout all of this, never to get anywhere near her.
Is there evidence of an actual transfer of money from Man to Eclectic?
I don't think
just as a book entry?
Well, I don't know whether it was just a book entry. We don't know.
You don't know?
I don't know, I'm afraid. Yeah, I haven't seen any evidence of whether it was actually just a book entry or whether there was actually money gone from one bank account to another.
Eclectic certainly in their accounts appear to have a lot of money in the account.
Yes, because there was reference to 112 million
Yes,
in their
which
account.
would suggest that that money did make its way.
Yeah.
But whether that was by way of book entry or actual money flowing in, I'm not sure.
Can I just be clear that if in fact one entered into this scheme, went to one's bank, said one wanted to exercise choice, invest, for instance, in a pharmaceutical company in the United Kingdom, invest £1 million and wanted to do this in order to gain access. If the bank then said, well, we lend it to you, but included a term that you had to invest in the pharmaceutical company, do you say that the investor would still have control in that case, or
Well,
not?
my lord, I'm going to come to that.
All right, okay.
That's
Well,
of the essence of the Court of Appeals analysis.
Yeah.
Exactly there is quite close to the heart of it, and the answer you won't be surprised to hear me say it's all a question of fact and degree. But may I come to that when I do? I'm going to turn directly to control, but that is close to the heart of the Court of Appeals reasoning, I fully accept. I'm not sure there's a terribly clear binary answer to that, but we certainly say that isn't the position here.
Do you accept that Eclectic is an active trading UK company for the purposes of row, whichever row 1?
Well, my lord, I think, my lady, I think that has always been accepted as the position so far. I mean, there seem to be a number of different ways in which this cat could be skinned, but in relation to the decision that was actually taken that's been challenged, that is the subject of these proceedings, I don't think anyone has taken the position that they aren't or couldn't be. I mean, there may be all sorts of questions. I'm going to come to them very briefly at the end on Section 35A.
Yes, I understand that you raised points in that
I mean, about, for example, whether this was indeed properly to be characterised as an investment at all, rather than something...
But in the sense that you don't need any of that if you're right on the control point.
I don't know. And at the moment we're at least subject to those additional potential doors in under Section 35 1A. We are, as it were, stuck with what we're stuck with. And I'll come to the concession bit under Section 65. There's been a clarity provided by the transcript, which I'll get to as well. But at the moment, control is the principal issue. Yeah. Can I turn to control then? Turn to control.
We're still going to come back to table 8B at some stage, are we?
I'm going to come. This is all going to be about table 8B.
Okay, good.
You will see if you go to table 8B.
In the Court of Appeal summary, is it word for word correct, or should we be looking at it?
No, Court of Appeal summary is perfectly adequate. It is word for word correct, I think.
Okay.
I hope, unless you picked up.
No,
In felicities, I hadn't picked up any
taking it on
trust, as it were, but I certainly haven't picked up any differences. So 127 takes you to the Court of Appeal's quotation of it.
So what was Ms. Wang's status? This applies to people who applied to enter the category before 6th of November 2014. So that
Yes.
is the... did she already have leave to remain in this country through some other?
No, I think she had leave to enter, but didn't have leave to remain at that point.
She had leave to enter under what?
I think under the same route, as it were. There are provisions in the rules for leave to enter, followed by an application for leave to remain. But it's the same route that's being used. And these rules have been chopped and changed, including recently.
But as I understand it, the first bit of 8B was a requirement for the leave to enter, the entry clearance.
Yes, although we don't have much indication as to quite how that decision was taken.
But I mean, there was discussion then about the fact that this was being reviewed at this stage, but it was accepted that could happen. But it appears that it was that was the test that was looked at that stage.
Yes, I think that's right. And so the key bit is money under his control and disposable in the UK amounting to not less than £1 million, which has been loaned to him. Sorry, Michael.
Just before we get to
Yes.
8B, is the difference between 8B2 and 8A explicable on the assumption that the draftsman thought that borrowed money is not money of your own?
Yes, I think it is.
Okay, that's a slightly bizarre...
It is a slightly bizarre
Why isn't
thing.
borrowed money my money?
Quite. But I think that's the way that means, I think of his own means without having to borrow it.
I think it must mean that.
I think it does, otherwise it doesn't make any sense.
Yeah.
Yeah.
But I mean, one can see, I suppose, at least some sense in that. You've either had to go into the financial institutions to get your hands on that money, or you don't. And that will probably explain also why B is divided into Roman 1 and Roman 2.
Yeah.
But that seems to be the sense of it.
Yeah.
And so just bear in mind that when you're looking at box 1B2, which is the bit that I've just cited to you, you notionally, as it were, for what it's worth, add in, as the Court of Appeal did, the wording of 245 capital E capital D brackets E, and that said that the assets and investment he is claiming points for, as a general point, as it were, the assets and investment he is claiming points for must be wholly under his control.
What does that mean?
Well, it adds in the upper tribunal's analysis of it, which I think must be right, at least at a basic level, it adds the idea that it's got to be completely under his control. I can't remember precisely how they put it, but the upper tribunal thought that added, that at least elevated the degree of control that was necessary. It wasn't just some control or residual
But there's
control.
an issue, isn't there, as to whether that applies to money, because of the differential way in which paragraph 8 refers to money, assets and investments.
My lord, there is. The Court of Appeal held at 44 and 136 of their judgment that the effect of the provision I've just cited is that the proceeds of loan must have been wholly under her control. And as you rightly point out, the respondent now seeks to say, well, that provision doesn't apply to money, in respect of which the applicant is claiming points, because 8b uses the word money distinctly from the word assets, and it would have been easy for ED to say money if that were intended. But we submit, in response to that the Court of Appeal's approach was the correct one. On a natural and ordinary meaning of the word assets, money is an asset, and it would be hardly artificial to interpret assets as not including money, particularly given that the provision in question deals with the assets and investment that he's claiming points for, so is aimed at being something composite. So 245 EDE sits above the detail of Table 8b and expresses a general requirement as to the necessary level of control. If the intention had been to exclude money from 245 ED, one would, if anything, have expected it to say that expressly, the assets other than money. And indeed, if the money relied on here is, as the Court of Appeal analysed it to be, in effect a shows in action under the loan, it's even more difficult to see why it should not be included in the term assets. So we do submit shortly for what it's worth, and it may be worth a little if it goes to the degree of control, answering the question what it adds, but the Court of Appeal was right so to treat it. And my submission...
But you don't have a shows in action if you're the borrower. It's the lender who has the shows in action once the money. The borrower has the money, the lender has the shows in action, the debt.
Well, yes, it slightly depends on whether you analyse the creditors are shows in action, which I think was the Court of Appeal's approach.
Well, I can see that under a contract for a loan which hasn't yet been advanced,
Quite.
there might be a sort of shows in action in the borrower.
But once the money has gone, and it's money.
Then the borrower's got money and the lender's got a shows in action.
Which is the right to claim repayment. My lord, yes, technically I think that's
So
right.
what slightly troubles me about yours and the Court of Appeal's approach is that assets and investments are not described in paragraph 8 as having to be under control, but you get that requirement in the bolt-on. Whereas money is referred to in paragraph 8 as having to be under control.
My lord,
You get a duplication of reference to control if you're right about the ambit of the bolt-on paragraph B, whatever it is.
I'm not sure I contend or need to contend that the reference to owns personal assets needs to have words implied into it which emphasise control in that context.
But that's what.
There was some suggestion in the papers that the the £1 million loaned could be included to make up the requirement in B1 of personal assets. Is that right, or have I misunderstood that?
I'm not sure what the answer to that is, or quite what the significance of it would be for the purpose of our debate.
It would be significant if, in fact, it showed that money was an asset.
Money was an asset, and therefore it was under his
and that therefore assets should include money. But my understanding was there was some suggestion to that effect, but I can't.
I'm afraid I can't place that either, but we'll see if we can find the reference to it, see if there's any light that can be shed on that. But my submission is that the Secretary of State was entitled to conclude that money loaned to Ms. Wang was not under her control, as required by Table 8B. And indeed, for good measure, neither the assets nor the investment for which points were being claimed were wholly under her control as required by EDE. One sees that that was the Secretary of State's view from the decision letter. I don't need to turn it up, but if you want the decision letter, it's at page 399 and 400 in relevant part of the Secretary of State.
Could the money in B2, just looking at what it means disposable in the UK, if you got a loan from a UK bank, an ordinary mortgage secured against a house worth £1 million, and you got a loan for £1 million secured
against the house.
Does that fall within B2? Is that disposable money, or?
My lady, yes. My submission is yes, it would be.
Right.
Because
of course,
the house would be would stand as security. So.
But the house wouldn't fall within B. But only the net equity in the house would fall within B1.
Yeah.
Yeah.
Because it would be charged to security payment to the loan.
Yes, you could have £2 million of personal assets outside the UK and a house secured by a loan in the UK. But then you would have to find your £750,000 for row 2 from somewhere else.
Yes, you've got paragraph 61A of Appendix A as well. If you just look back at paragraph 12 of the Court of Appeals judgment.
That's where the money is the security.
Yes. But my Lord Briggs must be right that the position would be that you could fritter away the £1 million loan money. You'd still be left with the security, and your house would be up for grabs, as it were. But it would be difficult to claim the value of the house as an asset to the extent to which it was committed against the loan.
The other thing about this scheme is that it was an unsecured loan.
It was an unsecured loan, it was.
So there wasn't any security offered back to the lender which would have depleted the £2 million necessary net asset value of the immigrant.
Yeah, I'm sure that was a thought out part of it.
Yeah. It being unsecured, there had to be other
mechanisms of control. Exactly so. That was the Court of Appeals point. Just coming to the concept of control generally, my submission is that in principle, control is a context-sensitive idea, a context-sensitive concept. Its natural meaning, one might have thought, is the ability to decide what should happen to something. If that sounds too simplistic, at least I have the comfort that it was the description or the definition given of the concept of control by Lord Sumption in Asset Land at paragraph 94, which is cited in relevant part in our case at paragraph 30.1, and if you want it in the raw, is at page 680 in the authorities part of the composite bundle.
What was that context? It was all very well taking a clean out of the blue a description of control, but you just yourself accepted that it must be context.
It is, and I mean, none of these, I'm not advancing any of these as it were, hardwired into our present context. Sorry, 680. No. Yes, it's a property investment scheme, as one sees from 94. It's going, that may be helpful to get the context from the head note. The head note is at page 653.
With respect to, I'm not sure this really assists. It's a word we're all familiar with, and it must take its meaning from the context. And your submission, as I understand it, is that control in this context means having some effective control over how the money is invested.
Yes. But, my Lord, I wasn't going to spend long either on this case or indeed on, other than to illustrate something very basic about the idea of control, or indeed on the other cases. I mean, I hope you don't feel we've wasted your time citing some of these other examples of cases involving control, but we of course accept that the cases we've cited in our case at pages 61 to 64 of the electronic bundle are not this context, but the common feature, it might be thought, is that they do all involve at least some degree of freedom to decide how the money should be used. That, again, at an incredibly basic level, is at least a common feature of the approach to control in all the various different and very different contexts that that the courts were considering in those. Often,
for what it's worth, I think the context is that of section 2352 of FISMA, which we can see set out on page 674 of the electronic bundle, paragraph 76.
yes, my Lord, I'm very grateful.
Or assumptions, judgment. The arrangements must be such that the persons who are the participants do not have day-to-day control over the management of properties. It's a sort of negative.
It's a negative thing.
Concept.
Yeah. I don't for a moment suggest that this is an equivalent context or can be directly transposed over. Just after basement level analysis, as it were, of the sorts of things that might fall within the natural meaning of control, but perhaps that's no more than to describe the concept in accordance with its natural meaning anyway. The position here, before coming to the Court of Appeals approach, perhaps 4 short points on the context here, and I've covered quite a lot of it already, but 4 short points here. We're dealing in relation to the immigration rule in question with the control of the money that has been loaned to Ms. Wang. The premise of box 1 is that the loan has happened, and the question is then whether she's in control of the money. So it isn't just the ability to enter into the arrangements that can be relied upon to establish control. That's the first point. Second point, at that point, under the arrangements that were made, Ms. Wang had no control over the money in the sense of free or indeed any decision making as to the steps contemplated in box 2, investing 750,000 or more into acting and trading UK companies, as to whether she should put some of it on deposit or anything of that kind. She could not, to adopt the language of Mr. Justice Kekowicz in Re Barney, which we cite in our case at paragraph 31.4, she could not, quote, if she will, put the money into her own pocket and pay it away as she pleased to someone else. Nor did she have open to her, to take the phraseology of Mrs. Justice Farby and BL cited in 31.3 of our case, she did not have open to her various possible courses of action as to what to do with the money. Thirdly, from the outset, the basis, the precise commercial premise, the basis on which the money was loaned was precisely that she should never have control over the money. or indeed over what happened to it in the hands of Eclectic. The terms on which the money was loaned were assiduous to ensure that it remained at all times in the hands of man/Eclectic. And indeed that, as the Court of Appeal pointed out, was the only way in which the scheme could work, because no security was provided. And fourthly, the deliberate absence of control is emphasised, we submit, by the fact that no element of the scheme or any of the hallmarks associated in the ordinary course of events with what it said on the tin. The loan bore no real relation to borrowing money by reference to the provision on economic terms, by reference to the cost of money, or terms designed to generate interest on with proper security. The terms were simply designed to generate what was in fact, and what the services agreement in the end, when disclosed, frankly described as a fee of £200,000. There was, of course, the reference to interest in the loan agreement from Mann to Miss Wang, and from Miss Wang, from Eclectic to Miss Wang when the money came back, but we saw the way in which those terms operated, with the discrepancies between who had the right to determine when the loans were repaid, with the right to turn the Eclectic loan into preference shares so that the differential in the interest rates in effect might add to the fee, add to the £200,000 fee. But the essential...
Were the preference shares transferable by Miss Wang?
No, my Lord, I don't think they were. She couldn't...
We'd have to look in the terms of the Mem and Arts, wouldn't we? It's the only place where we find out the rights attaching to the preference shares.
We would, and we haven't got those, I think, in the bundle. That's the same place as one...
I think you said that she couldn't transfer them for 6 years.
She can't for 6 years. That's in, that's para 18 of the Court of Appeal's judgment.
Yes.
Thank you.
So while it was a loan to Eclectic, the repayment was entirely in Eclectic's discretion.
Yes.
And once it turned into preps, there was a 6-year bar on.
There was a 6-year term, and of course the rate comes down. So you're effectively adding to the fee if there's a differential between the interest rates between the Mann loan and the Eclectic loan.
But she doesn't have to pay the interest on the...
No, because it all
the
stays...
loan that she takes from
Mann, because they're going to insure with an I, but she doesn't do that, or incur further fees.
Yes, no further cash is going to be required.
Exactly. And it looks as though they're taking on the repayment of that interest. Not entirely clear whether as agent or not, but in any event, the essence of it is not. I mean, if you, the example my lady was giving to me, if you and I go to a bank and say, "Would you lend me £1 million?" the bank will say, "Well, yes, I'm sure I will, as long as you give me a property in which you've got net equity worth at least £1 million, and then I'll have some proper security, and here's the rate of interest by reference to the value of money." So the loan didn't look much like a loan, and the investment end of things didn't look much like an investment agreement.
Well, the Secretary of State didn't award 0 points for the second test because it wasn't an investment. The Secretary of State awarded no points because the investment was not a qualifying investment.
My Lord, that's true.
So it's not a basis for refusal?
No, but the only reason I'm going to these elements is on Rossendale grounds.
Yeah.
For reasons I hope you will understand.
Yeah.
Look at the whole lot in order to determine the value of each.
Wanted to be clear.
That's how I'm putting it.
Yeah.
Yeah, if I can only get into investment if I can persuade you about 31A.
Yes.
Sorry, I asked you a moment ago whether the prefs could be transferred by Miss Wang, and you referred me to paragraph 18 of the Court of Appeal's judgment. That simply says there was a 6-year delay on redemption.
Yes, and then if
Do I need to read further on?
if you go on, yeah, it's I think the penultimate sentence, about 6 lines up. Preference shares carried note.
Couldn't be sold. Oh, I see.
Sold, transferred, assigned,
That's
pledged,
presumably
charged.
the Mem and Arts of Eclectic.
I'm assuming so, because I don't think we see that in the.
Yeah.
I don't think we see that in the agreement itself. So I was saying that the loan doesn't look or smell much like a loan, and the investment contract doesn't look or smell much like an investment contract, because, again, normally if I'm standing back from it, whether or not you see different degrees of control about the nature of the investment, normally what happens when you enter into an investment contract where some company is doing it for you, is you pay attention to the FSA required adverts that say investments can go up or down. You share in the decision making as to the investments. You have a stake, as it were, in what is invested in. Again, there's nothing equivalent here. All of this is just designed for presentational purposes. I wanted to come to the Court of Appeal's approach. Those are the four short points on control on the facts, building on the two key elements of the scheme I identified earlier. But the Court of Appeal's approach, the core submission on the approach of the Court of Appeal is that they took, we respectfully submit, too narrow and indeed too technical a view of the requirement for control, and were themselves wrong to conclude that the upper tribunal had gone wrong on the interpretation of that concept. The Court of Appeal specifically noted and found, as I've already indicated, particularly in paragraphs 40 and 69, that DK and NK, they found in terms that they retained control of the loan money at all times and did not lose control in practice at any stage. And that is an accurate finding of the true nature of the arrangements. And we submit that the error is that they failed to attach legal significance to those correct findings. Their reasoning appeared to be that the intended purpose of imposing the requirement of control was simply to ensure, as they put it at paragraph 52, the personal availability of the money. In other words, that the money was really that of the individual, not as a nominee for someone else. See paragraph 50. And that there was a, quote from 49, a level of comfort that the applicant would be in a position to make the investment. On that basis, it might be thought, an extremely limited purpose, if it had any real purpose, and that was obviously something that they puzzled about. And the restrictions on the use of the money, they concluded, were neither here nor there, because one could have a restriction of the kind that required, that my Lord Morgan put to me, the kind that required it to be used to pay or to invest in ICI only, and come back to that. But our answer in summary to that approach is it's too narrow an approach to whether or not there is the requisite control. And again, four short points, if I may, to back up that submission. Firstly, the requirement for loan monies to be wholly under the control or under the control of the applicant at a point prior to the investment also exists, we submit, consistently with the rules sensibly viewed as an aid to immigration policy, as it were, also exists to ensure that there is real economic substance underpinning both the investment and the individual. It provides real assurance that a person is someone who can persuade a financial institution to lend them the 1 million and can then afford to invest in UK trading companies, or at least as to 3/4 of the amount into UK trading companies. That is the basic underpinning purpose of this part of the rules.
So the fact that you can get the bank, the UK regulated bank, to lend you the £1 million is a sort of proxy of your creditworthiness.
Precisely so. And the whole idea of this, as one saw from 245E, was to create a route for, quote, high net worth individuals to make a substantial financial investment in the UK. And thus there's real merit in ensuring, through the emphasis either on it being their own money or loan money being wholly under their control, that the money is real in the hands of the applicant. It guards against, or is at least one guard against, precisely the sort of artificial sequence of agreements leading to no compliance with the basic intent of the route that existed here. That's the first and slightly broader purpose which needs to be taken into account. Secondly, and it goes back to my Rossendale point, the arrangements can and must be considered in the round and realistically, and with a Rossendale eye, if I can put it that way, for the wood, not just the trees. simply focusing on whether, in summary, the purpose is able to procure that an investment is made, and they therefore have control, as it were, is too narrow. It's both the asset and the investment that must be wholly under control, and here Ms. Wang had no control of either, as the upper tribunal correctly found. But in any event, it is permissible to judge whole control over the loan money by reference to the entirety of the pre-planned and pre-agreed steps. And if that is done, it is clear, and was found as a fact by the Court of Appeal, that Miss Wang did not have control over the money, or indeed the investment, and indeed the scheme was deliberately set up that way. See all the earlier submissions that I made.
Well, is that right? I mean, they said that DK and NK retained control, but they didn't say that the investor had no control.
My Lord, they didn't, but
No.
our respectful submission is
But that comes back to the question of whether control, two people can both be said to have control of the same asset.
My Lord, it does to some extent, but the reason I emphasise this point and that finding was to emphasise that the essence of this arrangement, the truth of this arrangement, if you apply the Rossendale analysis, was that it wasn't just that there were two people having different degrees of control in slightly different ways. One has cases in which, some of those cases about the retail cards, the Vice-Chancellor's judgment and all that, where you have two people with different degrees of control. Here, the very essence of the whole arrangement was that they should never get their hands anywhere near the money, because otherwise you'd be in the entirely uncommercial, uncontrolled, unsecured context.
When you're referring to the findings of the Court of Appeal, did you say that was at paragraph 69
And 40.
and 40? Yes, thank you.
Yes.
40 is where they're considering whether or not she has any option but for the money to go to man. And 69 is the "I do this with a heavy heart" paragraph.
Yeah.
And is also reflected in paragraph 71 of Lord Justice Underhill. But my submission here is that Ms. Wang did not have any form of control over the loan money at any point. The agreements reached ensured that the money went in totality in a single tranche to Eclectic. Ms. Wang could at most direct the timing of that, but that was it. You can't ignore the fact that she was only able to access the 1 million on the basis of all of the arrangements and agreements making up the scheme. There's no way that DK and NK were going to sign up to one part of this without all of the different elements of this being in place. The reality is that the control that she had was limited to the ability to sign up to that composite set of arrangements, enabling the money, in summary, to spin round in a circle for the £200,000 fee. Now, there may be questions of degree and fact involved in questions about the control of loan money. Of course, all loans will come with conditions, normally repayment, security, and things of that kind, and they may come with restrictions on the use of the money. The fact that such restrictions might exist, however, does not lead to the conclusion in all cases that any restrictions, whatever on their nature, cannot undermine control. And this, we respectfully submit, is a paradigm example of that. So my answer to my Lord Morgan's question, if you borrowed and were required by the loan, however unlikely it may seem, to put all the monies into a company satisfying box 2, the bank lends you money and says, well, I'm only going to lend you money on condition that the money goes straight from us to the shares of ICI, and then somewhere it's set up in that way, would there be control for the purpose of box 1? And my answer is, well, it's all a question of fact and degree. I don't exclude the possibility that two people may in principle have control over money. Indeed, in some of the example cases we've cited, that was indeed the position. They have control in one sense, I think, said the Court of Appeal at one point. But you can see a better argument that they would have control. If someone decides, for example, that they want to invest in ICI, and they then go to the bank and persuade them to lend for that purpose, and the bank makes it a condition in some way, quite how that would work, maybe.
Well, it's quite often that if the bank loan is then to be secured on the shares that are bought.
Quite. I mean, normally, and so I was about to say it may be quite complicated to work out how that would actually work, because it may be a condition of the loan that the monies that come to you then have to go, as it were, as an obligation. It's highly unusual for the bank to say, well, we in some way will keep control of all the funding and we'll do the purchasing. We'll be the name on the slip, as it were, when you buy the shares. But leave that on one side. If that were the position, you've made the prior decision that it was ICI you wanted and that was a condition in some way and you could make it work in a way that didn't give you control of the money because it was just a condition. Highly unusual, it might be thought, but at least one could see an argument. But here, none of the elements are more than simply components of the scheme. None conform to the commercial features that one would expect to see. It's all designed simply to create the appearance of meeting the requirements of the rules in return for a large fee, and everything else is directed to level everything out and make sure that the person doesn't have to put in any more money, so that the container in which the £1 million swills around, and query whether it's provided at all and how it comes back, but none of it is designed to do anything other than that. And that's why we say that it is significant that the Court of Appeal found that it was of the essence of the scheme that she should never have control of the money. So all she really had control over was her ability to decide to sign up to the composite set of arrangements that made up the different elements of the scheme. That's how we put the control aspect of it. When I come to paragraph 65 of Appendix A, and this is that the applicant has invested not less than $750,000 of his capital in the UK in active trading UK registered companies, and the exclusion is at paragraph 65B, which is what we're interested in, judgment of the Court of Appeal, paragraph 13 on page 128 electronically. So those are the four things, by way of, those are the four things. And as the judgment of the Court of Appeal at paragraph 59 noted, two of those find other definitions in other part of the legislative scheme, primary legislation, and two are not. Part J might be thought the short point we make about double taxation treaties, which isn't very interesting in our case at paragraph 44.3. But the prime candidate for consideration is pooled investment vehicle. I wanted just to start with the decision and the concession, because it's right that you should have an accurate description of where that is. So far as the decision is concerned, there is some question, at least, about what the decision maker actually did or actually decided. The decision itself, see, I don't invite you to turn it up now, but just to give them the time, but just for your reference, 451 in the electronic bundles at the bottom, the decision described the eclectic business as being to use your funds along with those of others to trade investments in other companies. That was their description of what eclectic was doing. And so, the decision said, falling within, as they put it, the type of investments that are excluded from qualifying under 65. So they didn't say it's 1, 2, 3 or 4. There's a bit of opacity about quite what it was deciding, no doubt. The type of investments is the phrase used. There's then the review of that decision, that's the internal appeal, if you will, and that's the relevant part of that is on page 441, electronic, second half of the page. And at that point, again, you've got the same, perhaps question-begging conclusion. But at that stage, at least, whatever else may be less clear, it appears relatively clear at least, that the decision maker and the review decision maker considered that 65B was in play and did operate to exclude on whatever basis, but without specifically plumping for any one of the four that are referred to in paragraph 65B. Certainly no conclusion, for example, that eclectic was not a pooled investment vehicle. The Court of Appeal, by the time the case got there, had the skeleton argument from the Secretary of State, and we didn't either of us appear at any stage below, I'm afraid, but so when we put in our case, we had the skeleton argument and we were awaiting the transcript. We've set out, I hope helpfully, at least what was said in the written skeleton argument by the Secretary of State or on behalf of the Secretary of State, including in particular at paragraph 55 of our case on page 73. And as one sees from those extracts, at least at the point of the skeleton, it appeared that there was a positive contention, as it were, by the Secretary of State in the skeleton that, quote, eclectic appeared to be operating as a pooled investment vehicle, and that paragraph 65 readily covered the arrangements relating to eclectic. The position now is that we have the Court of Appeal's judgment that records a concession at paragraph 61 by the Secretary of State or on her behalf that eclectic was not said to be any of the four entities in paragraph 65B in the decision made below, and that is probably right. Then at 67 it referred to another slightly bolder concession, as it were, that eclectic was not an entity listed in paragraph 65B. That's at paragraph 67 of the Court of Appeal judgment. And as I say, the Court of Appeal's conclusion in principle on that basis was that the wording of paragraph 65B set out exhaustively the nature of the exclusion, so that if you weren't within one of them, you weren't excluded. And we don't in principle challenge that conclusion. The rule excludes investment by way of the four categories in the vehicle. We don't say, therefore, that there is some floating, incoherent other category, as it were. So we're not seeking to defend that point. As I said, when we prepared our case, we didn't have the transcript, and we placed some reliance on what was said in the skeleton. We now have the transcript of the Court of Appeal hearing, and it does seem that in oral argument it was said positively that the Secretary of State was not submitting that eclectic fitted within any of the four categories. Again, if you want it, I'm not going to turn it up because of the acceptance that I've just indicated. If you want it in the transcript itself, it's 223 at letter E in the electronic through to the end of 226A is the exchange. But Lord Justice Newgee, it appears that everyone spends their whole life saying, looking at the time when addressing an appellate court, but that was the precursor to this particular exchange, 223E. But then at 224C, Lord Justice Newgee put to Mr. Mallock, is it your submission that it does fit within any one of those four particular phrases? And he replied, no, my Lord, that is not a submission that I make, and I do so with respect, my Lord, because that is not how the Secretary of State has put it. So that's the nature of it. So it does look as though there was a concession orally at the Court of Appeal stage that it didn't fit within, to the extent that one can take that from that exchange. But that's the height of it. We set out in the skeleton the approach to concessions, particularly it might be thought the rather forgiving approach of Lord Hobhouse in the Grobbelaar case to oral concessions that are made in the course of toing and froing, exchanging in courts, as opposed to more formally in a written document like a skeleton argument or a pleading. And we've given you all of those references to the judgment of Lord Hobhouse in that case, particularly at paragraph 56, see page 739 in the electronic bundle for paragraph 56, where he said this is not a case where a point has been conceded in the proper sense of the word, either by a pleading or a statement in court, as thereafter governed what issues do and do not arise. And we've also given you the reference to Lord Bingham in the same case, paragraphs 20 to 21, page 727. And important to both of their approaches was the question whether the statement had governed the issues or formed the basis on which the parties then proceeded. So, in the light of the, particularly of the transcript, I am not in a position to say properly that a concession was not made on behalf of the Secretary of State at the level of the Court of Appeal that this did not fit within. So the question then arises is whether or not it is appropriate for the court to permit, and it would have to do so, us to withdraw that concession. And I make three short points in favour of the court taking that course. First of all, we do submit this is a pure point of law, and that is a relevant factor when either a new point has been taken or, by analogy, when a concession is being sought to be withdrawn. That is an important aspect of it. It appears from...
Is it a pure point of law? Because this is the application of this paragraph to the facts about eclectic.
My Lord, it is.
What you said in your original opening wasn't a point of law, but a point of rationality.
My Lord, it is. The question is whether the meaning of that phrase applies to facts that have already been found, is perhaps the better way of putting it.
Okay.
So we have the facts, as it were, and the question is whether the meaning of pooled investment vehicle is apt to cover those. It's the non-controversy of the facts. It's the flip side of pure point of law that I should have put it on. The test claimants we've cited in our case simply, again, I know very familiar to my Lord Briggs, see paragraph 90 of test claimants 1097.
But do you say there's a binary answer as to whether it does or doesn't, or do you say the Secretary of State is entitled to evaluate whether it fits within one of those four?
My lady, it would be, well, again, it goes back to the basic description of how public law works in this sort of concept. The meaning of pooled investment vehicle is a matter of interpretation, is a matter for the court under Raisi. And once that meaning has been correctly discerned, that would be a matter purely for the court. Once that matter has been correctly, the meaning has been correctly discerned, it would then be a matter for rational evaluation by the Secretary of State. So that's the nature of the arguments that would have to happen. Secondly, I submit little or no prejudice. The point was fully argued below, both in the written submissions and in the oral submissions. There were full submissions in Ms. Wang's skeleton before the upper tribunal on the meaning of each of the terms. See page 1532 to 1536 in the electronic bundle. The Secretary of State made submissions in response. See pages 366 to 371. Ms. Wang then re-adopted her early submissions before the Court of Appeal. See page 1563 at paragraph 9. And the Secretary of State did the same, reiterating her position. See page 1570 at paragraph 14. And in the Court of Appeal hearing, Ms. Wang's counsel addressed paragraph 65B at pages 191 to 200. And there was then fairly extensive discussion between my learned friend and their lordships in the Court of Appeal as to the meaning of the term pooled investment vehicle. See pages 197 to 200. And the statement as to the relevant concession came after that. So we do respectfully submit that the point is ready for determination. There's been such submissions as there can sensibly be about the meaning and effect of it, and the facts are as found by the upper tribunal and or the Court of Appeal. So there's no need to go beyond those, and very difficult to see how anyone would produce any further factual evidence, no need for any of that. So you'd simply apply correct meaning per Raisi for the court, evaluation by the Secretary of State and so on, to whether it is in fact a pooled investment vehicle. And the third point, which is perhaps an aspect of the first two, is efficiency. if the efficiency,
Yeah.
if the decision is quashed as it currently stands by the Court of Appeal and has to be remade, the result is that the decision maker simply makes a specific decision about pooled investment vehicle and thing winds its weary way up again. So I do respectfully submit that if, of course it's an if the materials are there, if you don't need to find further facts, and if there is no prejudice, it makes much more sense for the court to deal with the matter at this stage. On that basis, some very short submissions, if I may, about whether it is or it isn't a pooled investment vehicle. My submissions there are that Eclectic used the funds of a number of individuals who were part of this scheme to trade investments in other companies. The description at the Court of Appeal's judgment at paragraph 60 is accurate, and indeed Lord Justice Popplewell's inclination or attraction to this in fact being a pooled investment vehicle was the correct one, I submit. A key aim of the exclusion appears to be to distinguish and to cut out these sorts of investments from the broader category of active and trading UK registered companies in box 2, no doubt, so as to deal with the concern that the investments that might be made by these sorts of companies, and indeed a pooled investment vehicle, may well not be into UK companies. And that indeed is reflected in the review decision at page 441 in the bundle, where it is said that all of these types of company could be used as a vehicle, I'm quoting from 441, could be used as a vehicle to channel the funds into other investments which may not be active in UK trading companies, the purpose of Tier 1 being to benefit the UK economy, not just through tax paid on investments, but also through the investments themselves. And that, I respectfully submit, is obvious and clear as a purpose from the immigration rules generally.
But I think you would have to say that if it is a pooled investment company, then even if it was one which marketed itself as only investing in UK businesses, it would still be excluded.
My lady, I think I would if it was truly to be characterised as a pooled investment vehicle. But I think what the point of identifying the purpose is to provide that guarantee. Maybe it overcovers, but at least it's designed in part to try and deal with a position. Whereas here, the money disappears through the conduit into, it looks like, into Russian companies, most of whom were controlled or owned by DK and NK themselves, which obviously raises questions about whether this is investment at all, or whether the money is entirely circular. When one's looking, therefore, for features, there is at least a sense in which there is, one can understand why the position was taken on behalf of the Secretary of State that was taken, even though legally it may be very difficult. One's looking, as it were, to identify what is it that is common to the four categories that are identified, even if those four categories are exhaustive. And the key one, perhaps, is that there are companies which invest in other companies. Money is provided from a range of people.
It's an element in pooling. Might it include the concept that the investments which are acquired with the investor's money are those in which, under the pooling arrangement, the investors have some shared proprietary interest?
My Lord, my respectful answer to that is that, well, I can see entirely why you asked the question, but my submission in response is that that would be to take a pretty technical view of that. Why would that proprietary feature?
Well, it's just that if a company is making investments, it's always doing it out of the share capital that's provided to it by its shareholders, which has in that sense been pooled. Or loan capital provided by lenders.
My Lord, of course, but if one looks to see something is being excluded by these four categories. Well, the question is what? The question is what are the common features? And the common features appear to be that these are companies which, as it were, exist to invest other people's money in a range of investments outside, as it were. Now, what the draftsman has done, it might be thought, terribly felicitously, but what they've done is to take a whole bunch of examples and turn them into an exhaustive list. The Court of Appeal were right about the meaning of the words by way of. But what are the common features? My submission is that if one's standing back and treating these as immigration rules designed to conform and to promote the policy purpose of immigration rules and of immigration, what are you trying to do? Well, we're dealing with tier one investment. You're looking to try and make sure that investment ends up and is put into UK PLC, if you will. And there is obviously concern that if you put the money into these sort of investment vehicle companies, then the investments at the very least might well be into lots of other companies and interests that are outside. So to come back to my Lord's point, if you're approaching it in that spirit, as it were, it's a little difficult to see why the proprietary interest that one's mind might naturally go to when you think of the concept of pooling should be an integral and necessary feature of promoting that purpose in this rule. That's, I think, my best answer.
Well, is there some significance to the word vehicle? I mean, if everyone invests in a PLC, that PLC may be a holding company which just owns shares in these subsidiaries, which are all the trading entities. I don't know whether if you buy shares in ICI, seems to be the example we're looking at, actually what you buy the shares in, what's publicly quoted is a holding company rather than a trading entity. But
yes. Well,
one wouldn't describe that as a pooled investment vehicle.
You wouldn't naturally, because you have a look at all the facts and circumstances and you recognise that ICI in its principal business, albeit for no doubt good corporate structure reasons, operated through its subsidiaries, is effectively a trading company that invests in fertilisers and all the other things that ICI invests in. One's got to try and make sense of the concepts that have been used, and as I say, if one's approaching this grouping or this descriptive grouping, you need to start by saying, well, what's it doing in the context of these rules, rather than standing back and saying, what might it mean in a different context? And what it's trying to do, evidently, when one looks for the common features, is to cut out those companies which exist, as it were, to invest in other companies.
The odd thing is that the 30-point requirement back in table OB on page 127 is that it should be an investment in share capital or loan capital in active and trading UK registered companies. The only thing to which UK there is being attached is the registration of the company. So it could be like Gerald Harrod's Buenos Aires, which was registered in London and carried on a department store many years ago in Buenos Aires in Argentina.
Yes.
It was a UK registered active trading company, and yet would absolutely fly in the face of what you say is the underlying purpose.
Well, whether one would describe Harrod's Buenos Aires or the domestic equivalent as any of the categories that are referred to.
Well, I don't think so. It's just an ordinary commercial company. It happened to have its business in Buenos Aires. But the point I'm making to you is that
it's not a very efficient guarantee of purpose.
If the real purpose had been that the money should be invested in UK business and trade, it's very odd that it's phrased in that way. You could have said active companies trading in the UK.
Well, one could, but self-evidently something is being cut out.
Yes.
By 65B, and you can't. You've got to therefore start by saying, well, what are they trying to achieve? What sorts of companies are they trying to leave out of this? And it looks like the common feature is that they're all, as it were, investment vehicles, and that's their essence. There may be questions of fact and degree. Query, I'm not sure. I think your Harrod's example might fall rather into my ICI example, where the nature of the company is something different.
Yeah.
So it wouldn't naturally fall within that group. But something is being cut out. And it may not be a terribly efficient. It may not be a terribly efficient achievement of the purpose, because, as you rightly point out, you can have a domestic UK company which, as it were, runs something which is wholly foreign. that wouldn't fall within it, well, so be it. But you've still got to try and do the best you can to identify at least the essence of what it is that is sought to be cut out. It looks like it's a company which is of a type, however, I say candidly described, of a type which has as its purpose and business that, as it were, conduit type investment.
On your interpretation of the term pooled investment vehicle, does it include the first three items in the list? And if not, why not?
Well, my lord, it might. It might. I mean, and I'm not sure that's necessarily a vice in my interpretation, because, of course, it's right that you've got those other descriptions in there, but you've still got to examine the essence of it, and there may be more or less overlaps between particular types of company that might fall within one or all of those descriptions.
But that would mean then that you'd have to interpret the final matter as it were, defining all of the as being the overriding consideration.
Well, my lord, you might if you have perfect logic in mind, or you might say rather more forgivingly that these are descriptive terms. You need to look for the essence of it. You can't make too much of a nonsense of it. They're obviously trying to cut out some species of company. As I say, the descriptions could no doubt have been done in a much more elegant way, and so be it. But so I think my answer to my lord is yes, in perfect logic, but we're not in a world of perfect logic.
No, but it might be questioned whether forgiveness should be given to the Secretary of State, who is both seeking to enforce the immigration regime and framing rules.
Yes, but this isn't
framing this rule as an exception to what would otherwise be an entitlement.
Yes, but there isn't. We're not in a position where you're. I can't think of the commercial example. I know there is one. It's lurking in the back of my mind. It's too long ago since I did commercial law. But it isn't an example of a case where you'll be presuming against the drafter. What you're trying to do is to make sense, realistically, of the nature of the exclusion that has been put forward.
Yeah.
You don't say, well, there's two ways and I can do this, and I'm going to hold that against the Secretary of State because they're the drafter. You say, how can I sensibly and realistically approach these rules with the purpose in mind and give them some sensible meaning and effect? That's the correct approach.
So that even though Eclectic is an active and trading UK registered company, because its business is pooling the money provided by shareholders or lenders into buying shares in other companies, and that's really its a vehicle for doing that it's excluded by 65.
Yes, and that seems to be the way in which the italicised bits, if you go back to page 127 and you go back to the box, that seems to be the way in which the italicised bits are set up. And the language is inactive in trading UK registered companies subject to the restrictions set out in paragraph 65 below. So it looks like they're scything out a category from the broader category, which assumes that Eclectic is a UK trading company. They're saying you may be that.
Registered trading company.
You're a UK registered trading company, but in one sense, as it were, but we're not having this particular species. That seems to be the nature of it. So the real question is, what does a species comprise? That's how we put it. In any event, my submission, I'm allowed to make it on the back of the Court of Appeal judgment, is that Lord Justice Popplewell was clever and right about his description of what a pooled investment vehicle looks like in paragraph 60. And his inclination was right. His only quibble was that the Secretary of State wasn't arguing it. So I do respectfully submit that is an issue which you are in a position to determine, you should determine on the basis of our interview. That leaves only section 31A. We've dealt with that in our case at 59 to 64. I've got very, very little to add to that. It's always a matter of discretion as to whether or not the court thinks that the answer is blindingly obvious. I slightly overstate the test in section 31A, which is whether or not it's highly likely that the outcome would have been the same even if the relevant error had not been admitted. But this is a point which arises at the at the level of discretion. So all the usual things that, discretionary remedies, all the usual things that feed into that. And it might be thought that the biggest point of the points that we potentially identify for your consideration under this head is whether or not, in the light of the findings of fact that were made by the courts below, and in the light of the description of the true nature of the arrangements applying Rossendale to them, this can properly be described as an investment at all. But it's a matter for you. I've got little to add, therefore, to what we've set out in our case as candidates for consideration for Section 31. As I rather promised, the service, my learned friend, I might be short of my allotted time, but I'm afraid I'm going to have to motivate, so you'll forgive me those of us.
Thank you very much.
Might need a little moment if he wants another lecture, there's more on here.
Yes, please.
Yes, Mr. Dupree.
Thank you, my lord. I thought I might start by giving your lordships and my lady a couple of references of which will give you the information I think you were looking for. The first is you wanted to know where you could find information about the 2% interest that was due, and also as to where you could find evidence of the restrictions on dealing with shares. I can't give you direct evidence of that, but these points were explained in, I think it's the Secretary of State's original decisions at pages 449 and 450. The original decision starts at 448, and then at 449, yes, at the bottom of 449, the last paragraph, you'll see the Articles of Association of Eclectics state that fixed dividends of 2% may be paid to Preference A shareholders.
And which shares did she get?
Preference A.
Yes, well, it deals with the 2%.
Yes.
And it deals with the restraint on redemption.
Yes, on
It says to get a
450.
dividend, you have to hold on to the shares.
Yes.
So there may be a commercial disincentive to sell, but those findings don't quite add up to a prohibition on assignment.
If your lordship reads down to the middle of 450, I think that's where it is this point. Moreover, paragraph 17 of the Articles prohibits holders of preference shares from disposing of the shares.
Yeah.
Without the consent of the majority of the ordinance. Yeah.
So that's just a point of reference. You also, one of my lords asked if there was evidence of the actual transfer of the £1 million from MAM to Eclectic. We have the instructions. I don't think we have evidence of the actual transfer, but there is a point of detail I just wanted to flag at the outset about this, because there was some suggestion that the monies that were flowing from MAM to Eclectic were somehow circular. They weren't. The monies were going, in relation to all the investors, from MAM to Eclectic to investments. Happened to be investments in the Russian Stock Exchange. But it wasn't going back and forth. And we can see that from paragraph 19 of the Court of Appeals judgment. Page 129. Which refers to a letter provided by Eclectic's chartered accountants. And that provided a detailed breakdown the investments made by Eclectic as of 30th of June 2019, these investments totaled 111 million odd pounds. And if your lordships will recall, the number of investors, I think, was 110 investors in the Maxwell Eclectic scheme.
I thought there were over 100.
I'm sorry?
I thought there were over 100 investors in the scheme.
Yes, so I said 110-ish.
Yeah.
I may be,
Sorry.
give or take a few, but over 100 certainly.
Yeah.
And not many over 100. So this is not a situation in terms of the overall scheme where the same £1 million is going back and forth in that sense. And it was therefore a scheme in which loans were being made by MAM to Eclectic 110 times-ish. Eclectic was then using that money to trade. It's just that it was trading in securities in the Russian stock market. So that's a big picture issue, which I'd like to just flag to your lordships at the very outset. As far as my...
There's no evidence about where MAM is getting the money, is there?
I'm sorry?
There's no evidence about where MAM gets the money from.
No, not that I am aware of, no. As far as the remainder of my submissions are concerned, I'm going to take it in broadly the order of our submissions and in broadly the order that my learned friend took it, which is first to touch upon the purpose of the immigration rules and the approach which we say, the correct approach which we say should be taken to interpreting the rules that we are concerned with. Second, I'll deal with control. Thirdly, I will address the paragraph 65B point, and then fourthly, I will address materiality. Now, in terms of the interpretation, the approach to understanding the immigration rules themselves, the starting point is not in dispute. It's the Mahad principle set out by Lord Brown. We accept that, and indeed we assert, that the relevant rules need to be interpreted according to the language of the rule construed against the relevant background, but that background involves a consideration of the function that the rules serve in the administration of the immigration policy. And it's that latter point which we put particular stress on, because a critical issue in identifying what the purpose of the immigration rules, and in particular the points-based system, was and is what we have described as the tick box approach. And it will be to throw out the baby with the bathwater, to undertake an approach now which completely disregards that tick box approach, which is the function of these parts of the immigration rules. And we respectfully submit, for reasons I'll explain, that the approach that you've been invited to take in this appeal is exactly that. Now, the Secretary of State identified the administrative policy undermining the points-based system in the white paper that was presented to Parliament in March of 2006. The Lordships have that. It starts at page 1254. Now, forgive me, but just notice that my copy is not have the pagination that your lordships have. If someone could help me with the executive summary, which is on page 1254. 259, yes, thank you. And your lordships will see that in the section that begins benefits, identifies the objectives of the points-based system. Firstly, better identifying and attracting migrants who have most to contribute to the UK, and secondly, a more efficient, transparent, and objective application process. Going down to 4, the applicants will find the system simpler to understand and the rules of entry clearer and more consistently applied. There will be more certainty about whether prospective migrants will be able to come to the UK. Then if we go over the page to 1260, and paragraph numbered 11, it was advertised as follows: points will be awarded according to objective and transparent criteria in order to produce a structured and defensible decision-making process. Prospective migrants will, prior to their application, be able to assess themselves against these criteria, reducing the number of speculative and erroneous applications. Now, just pausing there, one important factor to take into account, I would submit to your ladyship and your lordships, is that the way one approaches the immigration laws has to be considered also from the point of view of the applicant at the time of making the application, and not just, I would say, even at all, from the point of view of the Secretary of State, now explaining to your lordships what was intended subjectively from a big picture perspective, given the way the points-based system was advertised. But if we just move on.
Did you say subjectively?
I'm sorry?
Subjectively, I think you said subjectively.
Subjectively, yes. So if we could move to 1265, there is an explanation there about the problems of the current system. And at paragraph 7, it says, the current system is not a system that's easily understood by those who seek to use it or by the public. It's not straightforward one to administer. There is scope for inconsistency and incorrect decisions. Officers are often required to assess applicants' intentions, which is necessarily a subjective process. The lack of clarity on it and objectivity in the system fosters unfounded applications and creates burdens for potential applicants, employers, and educational institutions. And then moving just to the bottom of that paragraph, in summary, the complex sets of routes combined with subjective and bureaucratic decision-making process is inefficient for the Home Office and users of the system. And so what we get from that is that the purpose of the rule, again as advertised, was to take away a subjective approach to determining whether or not migrants complied with the points-based system in the various categories. And the groups that were intended to benefit from that more objective approach, the less subjective approach, were not just the applicants themselves, but the Home Office, to enable it to adopt a more efficient and resource-effective approach.
Was the then current system points-based at all?
Before this was introduced?
Yes.
My understanding is not, but I'll be corrected if that is.
I'm sorry, my experience of immigration law doesn't go back.
No, nor do mine, but I'm told there was a points-based system in relation to students.
Right.
And my understanding is that the categories developed and evolved and I think expanded over time. But I think insofar as there was a system, what I would imagine was the case was this was intended to make it more efficient than it had been. Then if we go to page 1269, and the second, the column to the right-hand side and towards the bottom, you'll see there that there is a heading which says meeting the test of flexibility, and then below that, a more efficient, transparent and objective process meeting the tests of objectivity, transparency, usability, operability and cost effectiveness. Then 1274, paragraph 40 under the section Architecture of the New System. It says benefits will accrue from the new points-based system not just because of who it allows in, but also because of how those people are selected. Particularly important in this context are the principles that the new system should be clear and user-friendly and based on objective and transparent criteria. Now, the courts have paid close regard to all of those objectives: transparency, clarity, objectivity. In a number of cases, Lord Justice Underhill has provided a useful summary of how those principles should be applied in practice in the case of Mudi Salage, which your lordships will find at page 795. The decision itself starts at 784, but from 795 onwards, Lord Justice Underhill summarises the authorities from paragraphs 36 through to 56. And I'll just pick out some of the things he mentioned there. In paragraph 37, referring to the comments of Lord Justice Sullivan in Alam, and Lord Justice Sullivan was talking about the policy behind the PBS. He says the immigration rules, the policy guidance and the prescribed form are all made it clear that submission of the specified documents with the application was mandatory. If the specified documents were not produced with the application, it will be refused. It was submitted that that had draconian consequences, but that was an inherent feature, the Lord Justice says, of the PBS, which puts a premium on predictability and certainty at the expense of discretion. And then towards the bottom of the next quote from Lord Justice Sullivan's judgment there, at the bottom of page 795, about 8 lines from the bottom, he says, the price of securing consistency, predictability is a lack of flexibility. That may result in hard decisions in individual cases, but that is not a justification for imposing an obligation on the Secretary of State to conduct preliminary checks that all the specified documents have been provided, or to contact applicants where they've missed out in providing the necessary documents. Imposing such an obligation would not only have significant resource implications, it would also extend the time taken by the decision-making process contrary to the policy underlying the introduction of the PBS. And then in paragraph 45, Lord Justice Underhill refers to the comments of Lord Justice Sales, as he was at the time, in paragraph, in the case of EK Ivory Coast, where Lord Justice Sale summarised the position as this: the PBS is intended to simplify the procedure for applying for leave to enter or remain in the United Kingdom in certain classes of cases, such as economic migrants and students. This is to enable the Secretary of State to process high volumes of applications in a fair and reasonably expeditious manner according to clear objective criteria. This is in the interests of all applicants. It also assists applicants to know what evidence they have to submit in support of an application. Pausing there, in the case of a Tier 1 investor, it also is intended to make it clear to an investor what investments would qualify and what degree, therefore, for example, of control is necessary, which is particularly important given the sums involved and also given the significant changes that many investors will make to their lives, including relocating their families, based on a decision to go down this route for the purpose of acquiring entry and then leave to remain and finally indefinite leave to remain. And carrying on in paragraph 45, Lord Justice Underhill says, this time referring back to Sullivan in a lab, he emphasises the importance of the PBS being clear and predictable, straightforward and reasonably automatic in its operation, describes it as intended to minimise the need for making sensitive and difficult evaluative judgments. Towards the bottom, the simplicity, predictability and relative speed of the process being in accordance with the thrust of the PBS regime as laid down by the immigration rules.
Sorry, which paragraph are you there quoting from?
I'm quoting from the end of paragraph 45 on page 797.
Thank you.
And indeed, in the upper tribunal, the Secretary of State's own case was that the points-based system was intended to have a standalone and self-contained status, and that it is intended to enable applicants to know the position by reading the rules as to how the rules operate and eschew complexity. You'll find that on page 238, that comment. That was in this skeleton argument before the upper tribunal. It's also important to note that the hard-edged approach that Lord Justice Underhill referred to, drawing from the other cases, is one that, in most respects, historically, the Secretary of State has benefited from in such judicial review claims. In Madison Lage, for example, there were 4 appellants, or 4 applicants, whose applications for judicial review were based on the fact that they had failed to provide specified documents required under the rules, which could easily have been obtained, and their complaint was the Secretary of State should have given them an opportunity to supply the missing document by notifying them of the fact that they were required and had not been provided. And the Court of Appeal in Madison Lage dismissed all of those applications on the basis that the rules were hard-edged. They had to be applied objectively, even if that meant harsh consequences. And that meant if you didn't provide the documents, the Secretary of State was entitled to reject your application without further ado. EK Ivory Coast is another example of this, a particularly harsh example. The applicant there was a student who was applying for a student visa, and she needed to provide confirmation from a college, a recognized college, that she'd been accepted onto a recognized course. She provided that letter, but before the Secretary of State made a decision on her application, the letter from the college was withdrawn by mistake, as a result of an administrative mistake. And the application was therefore rejected. She applied for judicial review, arguing that the Secretary of State, as a matter of fairness, administrative fairness, should have contacted her and informed her about the withdrawal of the letter. She had no idea of that having occurred. And her application for judicial review was was rejected on the basis that there was no such obligation applying the hard-edged and objective approach of the rules. So those are just a few examples about how this has worked to the benefit of the Secretary of State in the past. And that is the principal purposive context which we submit your Lordship should take in interpreting the rules. They are designed to eschew complexity, to eschew subjectivity, and to apply a tick box approach. But the argument now being run by the Secretary of State requires you to step back, evaluate an investment, and make an entirely subjective decision as to whether or not there is control and whether or not there was, in fact, an investment, and even further, whether the investment that was being relied on was one that the Secretary of State really intended should fall within this tier, taking into account Rule 245E. Now, I would ask your Lordships to turn, if you would, to Rule 245ED on page 488.
Presumably, this submission is only arguing for an approach, but it wouldn't be advocating, would it, that we just ignore all questions of form and substance and just take the form. It'd be very simple, tick box, objective, just look at what it looks like, tick the box, and that's it. But I assume you're not saying, or are you, that one should just take the form and forget about the substance?
Well, no. When we look at the minutiae of the rules in relation to economic migrants, it sets out a very specific mechanism as to how investments should be analysed and assessed. And what we say is, if an application complies with those requirements, and if you provide the evidence, which is quite specific in the rules as to how you prove an investment of the required nature, that is enough, because otherwise the tick box system wouldn't work.
I mean, would you go so far as to say that if a scheme was constructed under which the money did actually simply go round in a circle, but on the way round the circle you ticked each of the relevant boxes, then the court should ignore the fact that the last stage of the process takes all the money back to where it started, because it's ticked all the boxes.
I don't think that would be the effect of my submissions, because you wouldn't tick the box about trading, active trading. If it's going round in circles, then I would need to think about a more specific context. It would be difficult, I would submit.
I'm not so much asking you in the context of this particular bit of the PBS, I'm asking you in the context of your submission as a whole.
Yes.
The point-based system is a tick-box system,
yes,
and as long as you can come up with a scheme that ticks all the boxes, it doesn't actually matter if standing back, you can see that everybody ends up in exactly the same position as they started.
Well, I don't want to avoid your Lordship's question, but I think the answer to that is you wouldn't be ignoring, applying the rules and ignoring the reality in a situation where the money is going back and forth. Because one of the requirements of the tick box system is to show that the company you've invested in for investor purposes is active and trading. So if all that is happening is the money is going from A to B and back to A, there is no active trading. And that's how...
The company may be trading extremely actively, but just happen to provide the money that, as it were, primes the system by passing it back to MAM, which then comes round back to the company again. Maybe a thoroughly active trading company, earning a bit on the side by charging fees for schemes which enable people to get Tier 1 leave from A.
Can I
by all means, we're up to 1 o'clock anyway.
Yes.
So.
And I think...
I mean, what I'm really asking is, does your submission about tick box mean that you are not allowed to look at the matter of the round. Again, by all means come back at 2 o'clock, but that's what I'm getting at.
I understand your Lordship's point. Have I got time to take you to one more?
Well, we are at 1 o'clock, so it's probably a good idea to get into the detail at 2 o'clock.
I'll do that. Thank you.